You're listening to Let Me Tell You Why You're Wrong, all on Georgia Radio Network.
Welcome to episode 132 of the Let Me Tell You Why You're Wrong podcast. I'm Dave Roberts. With me is my partner in crime, writer, journalist, blogger, Jessica Szilagyi.
Hey. How are you?
I'm doing very well. How are you?
I'm doing very well also.
How was your week?
It was just a week. I love the end of the month because there's no meetings, and which I know I've complained that, I want to go back to meetings and I want everything to, go back to normal, which I do, but, it's just a little bit quieter time work-wise that allows me to catch up on stuff, and that's always nice, so.
It is at that.
What about you? How was your week?
Good. Hot, very busy. Still struggling to find equipment, but we're doing it. It just takes a little more work on my end to get everything done, but everything is good here as we kind of fumble towards the end of August. I guess as this show drops, it will be the last day of August and we'll be into September. Which
is kind of weird. Like the year is just zooming by and we have nothing to show for it.
Zooming by. Yes, it is.
Ugh.
And I am over Zoom.
I've never liked Zoom in the first place, so.
No. I mean, look, I get it. I get you need to have a means for having remote meetings, but at this point, don't we have the technology to have the Star Wars thing where you're sitting in a room and a bunch of holograms pop up?
That'd be pretty cool.
Yeah, I would bitch about that too.
Well, then we'd have to get dressed for our meetings and stuff, so I guess that would suck, but.
Yeah, no more button downs and underwear.
Yeah.
Yeah, I have to make sure I shut the camera off before I stand up at a Zoom meeting.
Yeah.
And I'm fairly certain that's how news broadcasters do it too. I mean, I have a vision that like anybody sitting behind the anchor desk is sitting there in shorts and a jacket and tie.
Yeah, or at the minimum, like comfortable shoes.
Oh yeah, or no shoes for that matter.
Mm-hmm.
Because I don't know if I'd want to walk around a TV studio with no shoes on.
True.
We want to mention Big Daddy Unlimited, our sponsor for the show. We're very excited to have Big Daddy. They are your direct source for all things awesome. Guns, ammunition, outdoor gear, accessories, Class 3 items, which means you can get a short barrel rifle, short barrel shotgun, or silencer. Those take a little additional paperwork, and you need to have those sent to a dealer that has an SOT, a special occupational tax, that can actually transfer it for you. But you can order those right there, have it sent, and your local person will do the ATF paperwork. You buy a gun, they will ship it right to an FFL. You fill out a 4473, walk out with your gun. But if you're buying accessories, a new upper for your AR, new optics, new sights, any other toys that go on your stuff that goes bang, it ships right to your door, and it is direct pricing. They don't have the overhead of a brick and mortar shop. So big thanks to Big Daddy Unlimited. So getting into the show, spaceport plans in Camden County include drone surveillance of private property.
Have you followed any of the spaceport drama?
Negative.
So, I mean, as anyone can imagine, there's been, from an economic development and a big business side, and the people who own the property and are advocating for this, they're all in, and whatever it takes, whatever the federal government says you have to do to be able to launch rockets from this spot that they have picked out, they are willing to do. And then, of course, there's there's a lot of, it's coastal Georgia, so there's a lot of smaller islands. There's military bases down there, but it's not a big area, and there's a lot of conservationists and wetlands and things like that. So you have two very different ends of the spectrum, and I think that having the military component gives you a demographic of people that are kind of just indifferent because they don't have roots in the community. So I say all that to say that this has been a controversial thing that's been ongoing for, years now. And I know that I wouldn't want rockets blasting off near my house, just for a number of reasons. But my biggest problem from a distance is that the county, Camden County, actually is the one that has been spending all the money to get this approved. They've already spent $8 million on this proposed spaceport that has had things go through the legislature and the county government, and the economic development actors down there have just been working on this for a very long time. So I say all that to bring you up to speed now, where they are, they have their proposed site, they have gotten certain levels of plans approved, and now they are at the point where the FAA is, I guess, one of the harder agencies to get the permit for, and they are reviewing the county's plan for what they plan to do to protect the community and the area around the launching site, in order to get approval. And doing so, the county proposed to the FAA that they would use drones to launch them up into the air on days that they would launch rockets, and surveil the area to make sure that there aren't too many people nearby, because the FAA requires, depending on the size of the rockets you're launching, the size of your launch pad and all these things, they require that uninvolved members of the public be kept at a minimum, and they have actual numbers, and I don't know them off the top of my head, and the news coverage of it hasn't really gone that deep into it. But to ensure, I guess, that they can launch these rockets, they are going to send drones up and make sure that whether they're home or on these little islands or just in the area, there aren't too many people.
Now, it's private property.
It is.
It's private. I mean, if I want to have 100 people to watch a launch in my backyard, it's my backyard.
And they're saying that would compromise the launch.
Then that's not the right place for it.
I totally agree.
So I said the Cape has, I would say square miles of space, literally space around it that belongs to NASA. That if you live in the general area of Cape Canaveral, if you live in Daytona or whatever, you're far enough away. It's a great view to watch launches. Mm-hmm. But if private property is too close to the launch site, then that's not the right launch site.
Well, and of course, drone laws and the regulations that individuals who have drones have to abide by compared to when a government entity or the FAA uses a drone, or a local government in conjunction with the FAA, the rules are different. We have much stricter guidelines and parameters of where and when you can use a drone. For the county to propose, not only for their own benefit and to recoup the funds that they've invested in this, that they are going to surveil private property, but to propose that that's how they'll ensure safety. I mean, you're telling me that, am I truly to believe that this project would entail, if they were planning to launch a rocket and they are, like you said, were 100 people or 50 people or however many people that was too many, you're telling me that they would just not launch the rocket, that they wouldn't send law enforcement or somebody else and ask them to disperse or to, move, or that it wouldn't end up in a situation of eminent domain where they just take the property? Am I supposed to believe that?
That's kind of what I was thinking was the natural result of that is taking that property by eminent domain. It's snatching up enough real estate around the spaceport in order to have the safe minimum distance required by the FAA. And we want there to be a minimum safe distance away from a launch anyway. It's just a good idea. However, when you start saying, and you're right, the natural movement towards, hey, listen, the drone says these folks have got 50 people in their backyard watching the launch. That's too many. Yes, the natural conclusion is someone goes and knocks on their door saying, hey, we need you to disperse, in which my response would be, no, this is private property, and I'll have as many people as I want here.
Right.
And which will lead to a local ordinance with how many people you can have in your backyard at any point. There's nothing good that comes from it. It sounds like they picked a horrible location to have rocket launches.
Well, and, I don't know what a good location to launch a rocket looks like. I understand what you're saying about in the Cape and how, the land around it and how far a distance you can see it. I totally get that, and I don't disagree, but you're also talking about a place that's been there for decades and the area has adjusted for it. And I know that, there's people, like the people who may have been there or may have been close by are long gone at this point. And I'm not saying that, there should never be growth or change or anything in an area, but when you're talking about launching rockets into space, that's a disruptive thing. It's very disruptive. Well, and it's not a private.
And when NASA took the Cape, there was nothing there.
Right.
You're talking about the 50s. There was nothing there. It was orange groves.
Some of this property they simply cannot take. Like they cannot take Little Cumberland Island. They can't do that by eminent domain. There are certain, because of some of the way that these places are protected, either local, state, or federal protections or guidelines.
And your note here, there are 102-acre lots and 46 cottages on Little Cumberland. And
their argument all along has, and this is not necessarily relevant to the drone footage part, but to the conversation we're having right now, their argument is, well, we're not so worried about, they don't want rockets launching, but they're more worried about debris or something causing a fire because not all the people live on those properties all the time. It's not a mainland thing. There's just different circumstances, and they're rightfully concerned about unintended consequences of it. Having rockets launched by your house is bad enough, but if you're going to surveil my private property to make sure that I don't, for any reason, is unacceptable, but to make sure that something I don't want can still go on and that I don't inhibit that's an unacceptable reason to me.
Well, if the drones were being used to surveil the property that is the spaceport, doesn't bother me. Doesn't bother me at all. It's the same thing as having a helicopter. You just don't have a person in the helicopter. The pilot is a mile away. That doesn't bother me. Flying over private homes and counting how many people are out cutting their yard is a problem. And what will that footage be used for? Is that once you open that can of worms, are they, as they go over, say, well, there's something suspicious going on over there. Let's just go ahead and check it out.
Well, and it's going to turn into not just the day of. It will expand. Well, we need to know, days before, weeks before. You know what? We actually are going to do like a weekly surveillance thing. It's just, it will never end.
Right. It will be continuously expanded because it is horribly convenient for the government to use a very inexpensive use of surveillance or means of surveillance to do that, to fly over people's houses to see what's going on. I still stand by the statement. I think it's the wrong place. If you've got people living that close, if you've got private property that close, it's the wrong place for it. Move somewhere else. I understand Camden County wants it because they want the money. But move it somewhere else. The rocket launches I don't think would bother me because they're not going all hours of the night. It's a scheduled thing a couple times a month, maybe. They don't put satellites in orbit that often. It's not a daily thing. It's not like living next to Hartsfield. And, rocket launches will be an event for people to go out and watch. When I was a kid, we used to go outside and watch the as I can't speak, the shuttle launches. Even as far away as I was in Coral Springs, which is just north of Lauderdale. We could sit and watch the stream of smoke, or in the night launches, we could sit and watch the flame go up and, kind of see it on TV and stand outside and watch it. It was kind of cool. We used to do it at school during day launches, go outside and watch them. So I don't think that will be as intrusive as this property that they're wanting to use for a spaceport, as they put it, doesn't have the square footage necessary to do it. And I'm all for private space exploration. I'm all for private corporations putting satellites into space and not using government funds. But isn't there a place in Death Valley that'd be a lot easier to do that?
Well, and we have exceeded that by the county having $8 million in county industrial park and all that. I mean, the county is so intertwined in this. The fact that the Georgia legislature has taken actions for it. I mean, the government is very vested in this, and not from the standpoint of, hey, we're just going to eliminate some restrictions to get out of the way so that, landowners and private property owners and or private interests, and then the company can sort this out. It's all woven in the worst of ways. So I'm less supportive for that reason alone.
Government wants the jobs, they want the money, they want the tax revenue.
Right.
Once they get it here, they can start taxing it. And it's everything. The technicians that work on rocket launches are highly paid. They're highly specialized, and they will pay taxes. Camden County wants it. All the businesses that will pop up around that spaceport, whether it's a coffee shop supporting people that are going to work Monday through Friday, or it's the company that delivers the fuel, all of that will be taxable, especially on the county level when they send that ad valorem tax, which if you own a business, you pay taxes on everything right down to your office chair because they say so.
Right.
I understand.
I think it sucks all the way around. I mean,
it does. And I understand why the county and the state want it. It's not the right place if they have homes so close that they need to put drones up to make sure people aren't in their backyards. I am less concerned with the idea of a piece of rocket falling on a house. It's so rare. It's so 1 in a million shot.
Well, the likelihood of I get what you're saying. The likelihood of that becoming a problem versus the government becoming a problem. I mean, it's almost guaranteed that the government will become a problem, and it's not right for them to do it in the first place.
Right. It's not their place to get involved in private exploration, private launches. If a private corporation wants to buy a large piece of land that fits its needs, well, go for it.
Before we move on, what would you do if it was a private company that wanted to do the surveillance? Obviously, they'd have fewer restrictions, but they'd have more restrictions and less. The FAA, like I said, the FAA and the governments, they have more leeway to fly drones and stuff in different places without permits, and I guess they'd have to get permission from the property owners, and if they didn't, then the site would be deemed unsuitable. So just by that logic alone, the fact that the government has to do it so that it can be done shows that it's not right.
I would worry less about a private company doing the surveillance because it's not. If they're really just doing a sweep of the area to make sure nobody is in the danger zone, that's fine. That's a private corporation doing it. They don't have the authority to send officers to anybody's house. All they can simply say is, we're a no-go for launch because we've got too many people in the area. And what I don't understand about too many is what's acceptable. Is one person out sitting next to his pool on a July afternoon acceptable if something goes wrong and 50 aren't? The logic kind of defies me. And of course, the way regulations are written, it's say you shouldn't, within so many square miles, you can't have but so many people. Because that's how regulations are written. But what's the acceptable amount of danger for how many people?
Well, and it shouldn't surprise anybody that this was not something that the county or that the spaceport advertised. There's a group of activists and landowners who have been opposing this from the beginning, and they filed Freedom of Information Act requests for the proposal and all of this, and that's how they found out. So, they haven't even been upfront about what they plan to utilize with the public anyway to make this happen. People had to go digging for it, which I'm all for, proactive citizens. But if this is as great for the community as it should be, you should be able to sell the greatness and talk about the trade-offs without having to hide it.
Right. So had someone not filed a Freedom of Information Act, they would have gotten to a launch and gone, what is that? It's a drone. Who's flying a drone? Look, like I said, the use of drones in and of itself does not bother me. It's a much more efficient way of doing what a helicopter was already doing. It burns far less fuel. It doesn't take a crew to operate it. It takes one guy sitting in front of a computer screen. So the use of the drone in and of itself doesn't bother me. The idea of flying over people's houses and counting how many people are outside bothers me.
Mm-hmm.
And even if it happens, it'll become a joke. It'll be, here comes the drone, guys. Everybody run inside. Everybody runs inside, wait for the drone to fly over, and then go back outside and watch the launch.
Lord.
It'll turn into a joke. But yes, I have a problem with the government doing it, and I do believe, I hate slippery slope arguments, but it will lead to, well, we can't get this thing off the ground once you send a deputy over to 123 Main Street and go and disperse that crowd. Which if they just go ahead and put some BLM flags up and say this is a protest, oh no, they're fine. They're fine. Go ahead and launch. Because we know you can't possibly get corona or be in anybody's way if you're having a protest.
No, everything's suspended.
Everything's suspended. Everything's awful. So feds execute a man who committed a crime on Navajo Nation reservation against the wishes of Navajo Nation and via a loophole in their sovereignty.
So you're pro-death penalty, aren't you?
I'm queasy about the government doing it. The government putting people to death.
Well, but
I don't have a problem with killing people that do awful things. Mm-hmm. But there's too much that's wrong with the justice system to allow it to execute people. There have been too many people that have been exonerated after 30 years when new evidence comes to light or witnesses recant to go and execute people.
Right. Well,
but I also, a la Matt Lowe, don't have a problem with a father whose daughter has been abused or anything like that and going and shooting somebody in the head and going with jury nullification.
Well, okay. Understood. Don't disagree. I didn't know that you were so open-minded to maybe getting rid of the death penalty. I'm anti-death penalty. I used to be super in favor of it, and after learning and understanding how the system works and seeing so many cases, like you said, I'm not in favor of it. So, but even if I set that aside for this conversation, I find this fascinating. I knew that Native American reservations, they have their own laws and guidelines and culture, and they're sovereign in a lot of ways. And this murder of 2 people happened on an Indian reservation in Arizona in 2001. And the Navajo Nation pleaded with the DOJ not to execute him. His name's Lesmond Mitchell, and he was a member of the Navajo Nation as well. But they pleaded with them not to put him to death, and they did anyway, because one of the victims' family, they wanted him executed. And so the DOJ overstepped the federal law and the precedent to do this. He was executed, like you said, last week. And I just think the whole thing is fascinating, because it's not supposed, victims have rights, of course. But if it happened on federal land, on Navajo Nation land, and it happened with one of their members, I don't know what the status was of the victims, but I don't understand how the DOJ can just ignore that.
Well, Lesmond Mitchell, 38, was put to death in Terre Haute, Indiana, via lethal injection on Wednesday of last week. He was convicted of carjacking and murdering 63-year-old Alice Slim and her granddaughter Tiffany Lee, who was 9, in Arizona in 2001. The grandmother offered Mitchell and an accomplice a lift as they hitchhiked on the Navajo Nation. They stabbed Slim 33 times, slit Tiffany's throat, and stoned her to death. Later, they mutilated both bodies.
So terrible crimes. Awful. Awful. I don't know if there was a confession. I don't know if, the challenges were never about the facts of the case. The challenges were particular to the land, the nation, etc. So, setting aside personal beliefs on the death penalty, setting aside the egregiousness of the crimes, you're left with just the fact that it happened on an Indian reservation.
He was 20 at the time, and his underage accomplice was sentenced to life in prison. Mitchell was also a member of the Navajo Nation and the only Native American on death row, or he was. Under federal law, the DOJ is supposed to defer to the tribe's wishes whether to pursue the death penalty, but in Mitchell's case, they used an exception with the carjacking charges to get around the law's wording. We always hear about people getting off on a technicality. And this sounds like the government started with the conclusion that we want to execute this guy and worked their way backwards to find a loophole in order to do it.
When the father of the 9-year-old and her brother are the ones that wanted the execution, and they praised President Trump for, because he just recently reinstated the death penalty. The administration just started executing people, and while everyone's been arguing about BLM and race wars and COVID and everything else, the U.S. government has executed 4 people in the last month, and at the time of recording, it will probably, or released, there will probably be 5, which is more people than we have in the last 5 decades because it was suspended. But we're not talking about those things, and it's hard to make the argument when you hear about a little girl's throat being slit and being stoned and mutilated and all these things. It's absolutely awful. But the father and the brother said, this happened on Navajo Nation land, but I speak for myself and my daughter. The Navajo leaders don't speak for our family. And just because they want this to be a Navajo Nation thing, we don't support that. But the law is the law, and we have this law and order president, and I'm having a hard time understanding why the victims are determining, or not even the victims, the family of the victims are determining the punishment in conflict with
right.
The law.
Well, they naturally want blood, and so would I. I absolutely would want blood, and if I were in their place, I would be making the same statement. But when you remove yourself from the situation and look at it objectively, is what sovereignty do we give to the reservation? And is it sovereignty when it can be superseded anytime the federal government wants?
Well, and there's one more point to that. The federal government made the argument that Mitchell, so the Navajo tribe is very focused on, spiritual life here on earth and in the afterlife, and they don't believe in taking a life. They don't execute for crimes in the Navajo Nation, from what I read and from what the article said. But the federal government's argument is that Mitchell abandoned that lifestyle when he took the life of Alice Slim and her granddaughter. And so therefore he was not subject to their protections. That is super dangerous because for all intents and purposes, it's similar to a religion. And if, at what point does the government say, well, you did this wrong and that's not in conjunction with your faith, so your protections for your faith no longer apply?
Right. There's a lot of strings to make the argument make any sense. There's a lot of false logic here. The fact is, it happened on sovereign Navajo land. The fact is, the practice is to allow the nation that on the reservation to decide whether or not to allow execution. And if that is their stand, and if that is the practice, the federal government violated the practice. Now, there was no way Trump was going to commute this sentence. There was no way. It just was not going to happen. Maybe if it happened in November, on November 4th, maybe. But there's no way facing an election, talking about law and order, that he was going to commute the sentence of somebody who slit a 9-year-old's throat.
He didn't have to commute it, though. You just don't put him at the front of the line.
I don't know that's in his control. And
you do the right thing with regard to the Navajo Nation. I mean, even if people don't agree with...
That's a concept too complex for the American voter.
Well, I was about to say, even if you don't agree with the Navajo Nation having the sovereignty that they do, because there's lots of people who don't, if you don't agree with that, I appreciate that perspective, but that is what is. If you don't want that to be what is, then eliminate it, and then we can have the conversation that we're having. But and this isn't going to come up again, because I was, normally I would say, look at what the president has done, but there's no other Native American on death row. But I just have a problem with how we got there, because you're no longer a Navajo Nation member simply because the government says, and because you didn't uphold the standards to the government's liking or belief that you should have in order to not have your life taken by the government. The whole concept of that, like you said, is too complex to explain to voters, and that's similar to why I don't write about things like that sometimes, because you can't articulate it. But it's wrong.
That's up to the Navajo Nation to decide whether or not he is still a member.
Exactly.
So if we give them sovereignty, that's it. It doesn't matter whether he's a member of the nation or not. It doesn't matter if he was an American that was passing through Navajo land. It happened on the nation. Their sovereignty doesn't only apply to those who are Navajo. We set aside this area for the Navajo Nation, said, this is yours. Govern it. And then we say, well, we want you to govern it, but no, you're not doing it right, so we're going to step in and we're going to whack this guy. In fact, his life in prison was good enough for his accomplice. And I get he was a minor at the time, but he certainly took part in it.
Well, and according to, if you read the timelines and everything and the what's out there on this case, which I'm a little bit of a nerd, it's a little too fascinating for me probably, but the juvenile is the one that did most of the I mean, they were both parties to it, but he was the one that kind of led the charge. And I understand he can't be sentenced to death, and it's so many problems. There's too much power for the government is what it comes down to.
Yeah, it's a lot to unpack. Mm-hmm. Because it's a complex issue. Whether or not Lesman led the charge or not, he's a part to it, and they're both guilty.
Absolutely,
it's a horrific crime. The biggest issue I have with it, here's the thing: like we talk about the death penalty, I'm not generally for it, but it's one of those things. It's not a hill I'm going to die on. I'm not going to go outside a prison and protest someone being put to death. I just don't care that much. My apathy on the matter doesn't prevents me from really inspiring any hardcore stand on it. I do take a hardcore stand on consistency and sovereignty. And this is something that the federal prosecutors used as a workaround because they wanted blood, because the family wanted blood, and because it plays well in the press. And the reason that his sentence was not commuted to life without possibility of parole is politics, because it would look horrible. Is this guy murdered a 9-year-old and her grandmother, and you are going to let him live?
Mm-hmm. So instead, we're left with an even more broken system, and oh well.
Yeah, there's no actual desire to fix the broken system at all. And I'm not talking about either party. There's no desire to fix the broken system. So, on that note, let's say these are our opinions, and not necessarily those of All on Georgia, certainly not those of any All on Georgia reporter not offering commentary on the show, and our opinions do not represent any opinions with anybody at Big Daddy Unlimited, our sponsor. Apparently, sentencing conditions you receive as part of your punishment for conviction of a crime are not punishment. Jessica, what happened?
Well, let's see. Where do we start? So, this is another topic that we've talked about a lot, so I thought it was, again, creepily interesting. But 3 years ago, a federal judge out in the 10th Circuit said that sex offender registry consequences amounted to cruel and unusual punishment. There were 3 men that challenged their treatment under Colorado's Sex Offender Registration Act. And it's just like Georgia's. They have the name, the address, the crimes, pictures online. You have to come in annually. If you're a predator or have a particularly egregious crime, you have to come in more. It's the public database, and you're rated based on the type of offender that you were and all of that. And just like here in Georgia, you can petition to come off early, and that almost never happens, but it's an option, and so that's important for later because it's a cop-out. But so the judge said that it was cruel and unusual. Of course, the state appealed that, and last week they overturned the ruling. But before we get into the ruling, I think it's important to talk about the types of people who are in this case, because I think it obviously, just like the subject we were just talking about, it's really unpopular to advocate on behalf of people who've been convicted of sex crimes, but we're not talking about somebody who has like a history of, dozens of children in a church or at a summer camp or something like that, or a rapist that was getting female joggers. This first plaintiff, his name was David Millard, and he pleaded guilty to second-degree sexual assault on a minor in 1999, and his sentence was 90 days in jail and 8 years of probation, and then a lifetime on the sex offender registry. So you're talking about 21 years on the sex offender registry when he spent 3 months in jail, which is less than some people get for DUIs, if they get convicted. And so he was part of the suit because he had to move a lot. He had to file 200 rental applications to find an apartment he could live in. He almost lost his job because a customer came to the grocery store he worked at and, like, threw a fit and all of this stuff. And he was having police show up to his home to do the checks to make sure he was living where he said he was living. And if he was at work or somewhere else when they came by, they'd leave like neon colored notes on his door saying that he was a registered sex offender and he needed to contact the Denver police, ASAP. The second plaintiff was Eugene Knight. He was convicted of sexual assault on a child in 2006. It was a child, but he was 18, and his sentence was also 90 days in jail and 8 years probation. And he's now a father who's married and cannot work. He's a stay-at-home dad because he's unable to find work, he says, and he's not allowed to drop his kids off at school or school events or bus stops and things like that. And then the third plaintiff, who is probably the most difficult one to comprehend and to talk about, is Arturo Vega. He pleaded guilty to a third-degree sexual assault, and it was a crime he committed when he was 13. He was supposed to be on the... Juveniles aren't on a public database. If they've committed a crime like this, the state maintains a database, and the information is private, and then when they become an adult, they might have to still check in and adhere to certain standards for a certain number of years, but the public is not aware of that. And we've been pretty adamant about that for a very long time, that juvenile records aren't supposed to haunt adults. Well, apparently when he was 13 and charged with this crime, he did not understand all of the registration requirements and did not adhere to them properly. So they put him on the public list, and now he's on the public sex offender database. He's been asked to be taken off twice because he's not on there for his crime. He's on there for failing to register as a juvenile properly. And the judges are saying that he can't come off the list because he cannot prove he is not likely to commit another sexual offense. And again, this was over a decade ago. So the people that we're talking about, yes, there are always extenuating circumstances, but we are all of the belief that if you spend 90 days in jail for a crime, you're not a serial rapist or a child molester or somebody who is a immediate threat to all of society.
You get more than 90 days for pot. Mm-hmm. A victimless crime.
Well,
the
not
juvenile
Colorado.
one. Let's. Yeah. Well, I guess we'll go in order. The David Millard, second-degree sexual assault on a minor in 99, 90 days and 8 years of probation. I'm with you. If it was so egregious, and 90 days in jail, that's not prison.
Right. He was at the county.
That's county lockup.
Yeah, exactly.
That's county lockup. You do your 3 months, and then 8 years on probation. And this is 21 years ago. He was 18 at the time. No. It's hard with... I'm sorry, you got the wrong guy.
Well, he wasn't 18. We don't know how old he was. But, again, I don't know how old the gentleman is even now. So I probably should have looked that up. But we're still talking about 90 days in jail and 8 years probation. That was correct.
And it's second-degree sexual assault, 90 days. Obviously, the prosecutor felt, because he pled, felt that was appropriate. That was appropriate to the crime. Now, we don't know the ins and outs of the case and exactly what that sexual assault was. And look, there's a case here in Cobb County. It's actually another air conditioning company owner that got drunk and grabbed some girl's butt that worked at a bar, as a hostess. Inappropriate assault, absolutely. But it turns out she was 16. She was just working as a greeter. And that could very well land him on this list.
Well, look at the the guy who smacked the butt of the reporter on TV, the jogger in Savannah last year. I mean, it's the same. That's a sex crime that they charged him with. So those are the type. I mean, and no, that's not everybody on the list. Don't get me wrong. But exactly what you just said. The prosecutor agreed to this, and prosecutors get it wrong. But who in their right mind thinks that 90 days in jail and a lifetime on a public registry is appropriate and balanced?
And how does that public registry keep anyone safe?
It doesn't.
Now, I'm not saying do away with the registry. There are really, really bad guys that sentencing guidelines don't allow us to throw people in prison for life for a lot of these things. There are a lot of bad guys that you really need to know to keep your kids away from that house. But you're right. If the crime was minor enough to justify a quarter of a year in jail. Now, I don't want to go to jail for a night. Don't get me wrong. I'm not saying I could do 90 days standing in my head. No, I'm not saying that. I'm saying it was so minor that 90 days in jail and 8 years probation was acceptable to the prosecution, that they didn't want to go to trial with this. And this is a feather in a prosecutor's cap. If you put a child molester behind bars, if you put a predator behind bars, that's a feather in your cap, and that makes the news.
For elected prosecutors, mind you, people who want to have those feathers in their cap and be able to say, we locked up X number of people this year, and this is, we had a combined number of this many years in prison. And the next guy, the one who's now a father who did it when he was the one that was 18. Should an 18-year-old be messing around with someone who is not of the age of consent or whatever because it was attempted sexual assault. So we don't know if we don't know the details, but he's a father now, and he's not too dangerous to be around his own children, which is a sentencing guideline for some sexual offenders and predators, but he's on a registry and has this stigma and
right. He obviously is trying to make something of his life. And he's being watched. If he were stepping out of line, they would know it. The third is the most egregious to me, which is the 13-year-old.
It's disgusting.
Third-degree sexual assault. Now, I don't know the guidelines between first, second, and third in Colorado. No idea.
But you're smart enough to know that third comes way after first.
Hey, you give me too much credit. But he was 13. 13 years old. And what happened? We don't know. Was he playing doctor behind a bush? I have to believe that if he grabbed a girl off the school bus and tried to force her, again, behind the bush to do something she didn't want to do, it would be a lot higher than third degree. I would hope.
Well, and even if it wasn't, the law says that juveniles aren't on the public registry. And to say that because he was a child and didn't register properly, that he's now on the public registry for life, I'm sorry, but that's horseshit.
Absolutely. This is a life sentence for a kid who did something at 13. And again, third degree. I'm not excusing any of it. But we don't know what happened. We'll never know what happened, especially with Arturo Vega, because he was 13. Mm-hmm. And we shouldn't. All those records should absolutely be sealed. Be sealed. Absolutely be sealed. Because it's not necessarily indicative of him as a person. Again, he pled to it. This is something that They got to family court, or the juvenile court, and they sat down with them and said, look, plead to third degree. It'll go away. You turn 18, you move on with your life. And I guarantee that's how it was sold to him and it was sold to his parents. Is you're going to go into treatment. You're going to go to a special school. You're never going to see that girl again, or boy, or whatever. You're going to go to a juvenile rehabilitation program, whether it's the one that goes on down in South Georgia there, where they go to a mock boot camp or whatever. I think we had a story on them too. Whatever it is to put them on the proper path for life, get them through high school, seal it, let them go, whether it's to go to work or go get a college education and move on with his life and leave that sealed in the past. And again, those records are available to law enforcement. If he ever stepped out of line again, those records would pop up and say, okay, he's got a history of this stuff, and he'd go away for a long, long time.
And we're spending a lot of time on the actual crimes and the sentencing, but it's important because, again, this isn't everybody, but these are the types of people who get screwed by the system and a one-size-fits-all law. Because what the court said was that the burdens imposed by sex offender registration aren't punishment, and the Eighth Amendment is irrelevant. And because apparently there's some SCOTUS ruling from a while ago that said that sex offender registration is civil rather than punitive, which I do not agree with, because it comes with your sentencing. They're in statute in every state and at the federal level. Like the registration process is in statute and it's part of the sentencing. If you were convicted of this crime, this is what you have to do as a result, and sex offender registration is one of those things. But listen to this, what they said. Even if there is no evidence that publishing information about people convicted of sex offenders protects, well, that's my opinion, that, we don't have any evidence that this protects safety. They said the goal of the legislature in each state putting these registries in place is prevention rather than retribution. And therefore, any harm inflicted by the policy is incidental. And so the quote was, the statutory text itself explains that it was not the General Assembly's intent that the information contained in the registry be used to inflict retribution or additional punishment on any person, but rather the law was intended to address the public's need to adequately protect themselves and their children from those with prior sexual convictions. So therefore, who cares what it does? If that's what the legislature intended to do, then that's what we're going to say it is. Which, when the Court of Appeals said any policy is incidental, that's not true. It's not a policy. It's a law. It's a statute. And that is proven by our the 13-year-old's case, because if it was a policy and he violated it, he wouldn't end up on the public registry. But he's on the registry because he was charged with another crime because he violated the law by not registering.
Well, that's the thing. As my point with the whole thing is, if you don't follow these statutes, if you don't register, you are thrown in jail. You're arrested. So it is absolutely not civil. If it was a civil case, you'd get sued for not registering, or you'd get a fine for not registering, not thrown in jail. It's absolutely not civil. A civil case is your lawn is too long. We need you to cut it. Here's a $100 fine. That's a civil fine. Failing to register is not civil. It's criminal. They don't send the marshals out to do it. They send, well, in my case, they would send the sheriff's department out and they arrest you for failure to register. In fact, I see those booking photos come across all the time. Failure to register a sex offender. Mm-hmm. God, we've defended the worst people in the world today.
Well, we should. I mean, it's true, but I mean, we can't help that all these people are wrong.
And let me tell you why. And that's the thing, is standing up for principle doesn't mean standing up for awful people. It means standing up for principle.
And like you said a few minutes ago about the Navajo Nation, I mean, it's a consistency thing. And to say that it's policy, or to say that the legislature's intent is okay, it does, prevails over the actual institution of it, is not right, in my opinion. And I think this is going to end up going back to SCOTUS again, because the Sixth Circuit in Michigan a few years ago, they said that the registry was punitive, and that, certain requirements couldn't be imposed on certain people because it had to do with like a retroactive application. And in determining whether or not the registry could be retroactively applied, they determined that it is punitive. So I think that the Supreme Court is going to have to rule on this again. And I hope that they take a better approach, not because, whether you think it's effective or not is irrelevant. It's not being used properly, and that should be a concern to anybody, because all it takes is one wrong accusation and it's your ass on the registry and your life that's ruined, and it might not be it might not be justified.
Right. So we want to hear what you think. Let us know when you see this podcast pop up on whichever app, Facebook, or anywhere else that you get this podcast. Like us and share us on social media. Interact with us. Tell us why we're wrong. Jessica, do you have any closing thoughts?
No, I'm deferring to yours because I think it's going to be interesting.
I have a real problem with this overcharging in a politically charged environment. We find out last week George Floyd had a lethal level of fentanyl in his system. We also find out that there was no injury to the upper neck or the neck or upper back of George Floyd from being knelt on. The rush to charge this officer with murder may very well end up with him walking. Instead of waiting for all the facts, waiting for the results of the autopsy, the complete results, including tox screen, to come out, and find out that maybe he was a complicating factor, and it could be that he still committed a crime. And if that's the case, he certainly needs to pay for it. But overcharging may mean he walks free. And then where are we? And then we're right back to riots in the street. Secondary to that is the kid in Wisconsin. They charged him with murder, and this is the kid that went to protect a car dealership in Keone or whatever it is, Wisconsin, and took his AR, which is legal for him to possess an AR at 17. It was legal for him to be there, whether he made good judgment or not. He defended himself. He killed two, blew the snot out of the arm of one of the guys that pulled a gun on him. But the rush to charge the kid with murder, I think is not going to serve the community. And I think it absolutely has to do with these prosecutors, much like Paul Howard, wanting to appease the mob, and the mob will not be appeased. So, there's my 2 cents and my soapbox on that. For Jessica Szilagyi, for Eric Cumby, our editor, big thanks to Big Daddy Unlimited, our sponsor. I'm Dave Roberts. Have a great week.